Get ready. 3, 2, 1, start. The present application under section 482 of the code has been filed seeking to quash the entire proceedings of criminal case number 412 of 2020 arising out of NCR number 70 of 2019 under sections 323 and 504 of the Indian Penal Code 1860. The learned additional Advocate General has taken instructions which indicate that an order under section 155 of the code was passed by the magistrate directing investigation and pursuant thereto a police report under section 173 of the code dated 29/7/2019 was placed before the magistrate, upon which cognizance was taken on the same date. The principal submission which is sought to be raised to seek quashing of the proceedings is that the complaint having been made in respect of non-cognizable offence of the police report also having been submitted with regard to non-cognizable offence in view of the explanation to section 2 of the code, the police report shall be deemed to be a complaint and the case would be required to be proceeded with as a complaint case. In support of his submissions, learned counsel places reliance upon the judgment in the case of Rakesh Kumar Sharma versus State of UP. The learned additional Advocate General has controverted the aforesaid contention by submitting that the explanation to section 2 of the code would come into play only in a situation where, to begin with, the complaint which was lodged was in respect of a cognizable offence, but after investigation the police report which was submitted disclosed a non-cognizable offence. He submits that in the present case, where the proceedings were initiated pursuant to registration of a case in respect of non-cognizable offence and the same was investigated upon an order passed by the magistrate under section 155 of the code and the police report subsequent thereto disclosed non-cognizable offence, the explanation under section 2 of the code would not be attracted. To support his contention, learned additional Advocate General has placed reliance upon the judgment of the Supreme Court in the case of Kesab Lal Thakur versus State of Bihar. It has further been pointed out that looking at the nature of the offence disclosed in the police report, the case which is to be tried would be a summons case and the procedure prescribed for the same would be as per chapter 20 of the code, wherein there is no distinction with regard to manner in which the trial is to proceed between cases instituted on a police report and those instituted otherwise than on a police report that is a complaint. It is accordingly submitted that the present case being a summons case, there would be no material change in the procedure of trial, and as such the applicant cannot be said to have been prejudiced by the order of cognizance passed by the magistrate. Stop.